The hearing yet. We're going to be delayed about 5 minutes or so. We have some discussion going on in the room. So this is just an announcement for everyone listening on the live stream or on the WebEx. It is 8:33 and after time. We'll begin in just a moment or two. And we are in the courtroom of the Missouri Public Service Commission. We are in the middle of our evidentiary hearing for the general rate increase request by Evergy Missouri Metro, file number ending in 0129, and Evergy Missouri West, file number ending 0130. For the record, we are joined this morning by Commissioners Holzman and Kolkmeyer. Welcome, Commissioners. We have two issues for this morning, and we are going to combine those issues as they have limited witnesses, and those witnesses generally have testified on in both of those, with one exception. The plan then is after that testimony concludes, we will recess until 1 p.m. There is a 10:15 agenda scheduled in there for the commissioners, and we will, of course, be breaking about 20 to 25 minutes before that start time in order to allow everyone on the staff's technical side to switch over the live streams and various things. All right, let us get into mini opening statements, if any party would wish to give them. The company.
Thank you, Judge. Carl Zobrist on behalf of the Evergy Companies. Just very briefly, we have one witness to present today on both the resource planning issue. I understand that's been marked as exhibit issue number, Roman numeral number 3B, and then on the analogous rate base issue, Roman numeral 15. That witness is Kayla Messamore, M-E-S-S-A-M-O-R-E. Ms. Messamore will also stand for cross-examination on the Sibley issues that we tried last week because she was unavailable. If anyone, the commission or parties have questions of her. With regard to the resource planning issue, our position on this issue, which is whether the company should be required to conduct a full retirement study of its coal fleet using optimized capacity expansion software. This is an IRP issue for the integrated resource planning dockets, and that's numbers ER-2022-0201 and 0202. Those issues relate to software mainly. From our standpoint, there are other issues, of course, in that case. The company is now using this software. There is some debate about what they are doing, why they are supposedly not doing something. Those issues do not need to be covered in this rate case, and so we believe that the answer should be no. These issues should be dealt with in those integrated resource planning dockets. The company is prepared to respond to the issues raised by staff and Sierra Club and others, I believe, in about 10 days. As far as issue Roman numeral 15, we have in this case, and we've settled most of the resource planning issues. The parties have. It's for the commission to decide what to do with those stipulations. But we had disallowances proposed by the Office of the Public Counsel because, in part, Evergy Missouri West did retire a coal plant early. This is the flip side. Sierra Club is saying you should accelerate the retirement of your plants, and they say, although we understand that you can't shut down coal plants just immediately, they propose a disallowance of about $100 million to deprive the company of revenue for capital expenses and for operating and maintenance expenses based upon the fact that there is a disagreement in how retirements are modeled and how the software is run. We do not believe that this raises a serious doubt as to the prudence of the operations of the company, and certainly it does not raise a serious doubt in terms of the proposals that have been presented in this case. We understand that the prudence standard applies in this situation. We do not believe a serious doubt has been raised, and we ask that their proposed disallowances be rejected. I would just also point out that there has been very little discussion of system reliability in light of what is going on in the country today, and in particular in light of the fact that Southwest Power Pool has raised the reserve margins recently to account for what they believe is a reliability issue that we all need to address. So in light of that, that's all I have, Judge. Be glad to answer any questions.
Are there any commissioner questions for Mr. Zobrist?
No questions, Judge. Thank you.
Thank you, Commissioner Holzman.
Okay, thanks, Judge.
Thank you, sir. Let's move on. Opening statements. I have staff next. We're going to pause for a quick introduction first.
May it please the commission, good morning. It is again my privilege to introduce a new attorney to the commission. Don Cosper joins us from the University of Arkansas Little Rock School of Law. He just began it, and this is his first opening statement. So,
Mr. Cosper, welcome to the commission. Please go ahead.
Thank you. Good morning. May it please the commission. My name is Don Cosper, C-O-S as in Sam, P as in Paul, E-R, and I represent staff. Although staff takes no position on rate base or resource planning, staff witness Jordan Hull has filed informational testimony in this manner and here to answer questions on that testimony. Mr. Hull discusses generation unit classes, how a diverse generation fleet improves grid stability and reliability, and why generation types do matter when planning retirement for units. Thank you.
Thank you, Mr. Cosper. Are there any commissioner questions for one of our new staff attorneys? Hearing none, thank you very much, Mr. Cosper, and welcome again. Sierra Club, would you like to make a mini
Good morning.
opening? Good morning. Go ahead, ma'am.
I just want to make sure you all can hear me since I'm participating remotely. Don't want to mess up your record. Great. Good morning. May it please the commission. My name is Sarah Rubenstein of Great Rivers Environmental Law Center, and I'm appearing on behalf of Sierra Club. I would like to start by recapping the legal and regulatory requirements that a utility must prove in a rate case. First, in a rate case, the utility has a burden to prove that all its costs are reasonable. This includes all costs associated with maintaining generation assets that are included in the test year. Second, it follows from these general principles that the utility has a burden to prove its generation planning decisions are reasonable in a rate case. It's important to remember that integrated resource plans, or IRPs, in Missouri are not reviewed in contested proceedings. There's no formal approval of the utility's decision-making in an IRP docket. This commission does not rule on the substance of an IRP. Rate cases are therefore a primary venue for protecting regulated customers from imprudent power plant and other resource planning decisions. At a minimum, where challenged, a utility must carry its burden to show that a particular generating unit's test year costs were prudently incurred and that it was prudent to operate the plant throughout the test year. But because a generator would reduce spending as it approaches a prudently selected retirement date, the obligation to plan reasonably should extend beyond the test year as well. For example, a prudent utility would avoid substantial upcoming environmental capital costs if a particular plant was slated for near-term retirement. I would also like to point the commission to a few facts relevant to Evergy's request to include coal unit spending in its customers' rates in this case. First, as a factual matter, Evergy's offered little evidence to support maintaining its coal units through its test year or beyond. Evergy, Metro, and West seek approval of test year capital spending of $87.8 million at their coal units, and that figure is broken out by utility in Sierra Club witness Glick's direct testimony at page 12, table 5. Evergy has asserted that the amount of O&M it seeks to charge customers in the test year is confidential, though the O&M figure is also significant and can be found in the confidential version of Sierra Club witness Glick's direct testimony, again at page 12, table 5. Evergy did not file any direct testimony in this case supporting or defending its test year spending at its coal units. The only rebuttal testimony that Evergy filed in support of its coal spending is that of witness Messamore, which offers no independent evidence of the value of maintaining the coal units through the test year. The Messamore testimony primarily points to the company's IRP process to support its request to include coal costs in customers' rates. Second, the economics of Evergy's coal units have been and continue to be marginal compared to alternative and replacement resources. Existing coal-fired power plants are increasingly uneconomic in the U.S. and the Southwest Power Pool. They are poised to become even more so in the future because of both economic and regulatory forces that will continue to increase their costs to operate relative to alternatives. Higher operational costs result in lower utilization and capacity factors. The historic and projected capacity factor data for Evergy's coal units is provided in Figure 1 on page 23 of the confidential version of the Glick testimony. Sierra Club witness Glick evaluated the historic performance of Evergy's coal units between the years 2017 and 2021. Ms. Glick used Evergy's actual revenues and actual costs, including a capacity price provided by Evergy to represent the unit's capacity value, and found that the company's coal units incurred costs in excess of their market energy and capacity value over the past 5 years. Evergy has claimed that Ms. Glick's calculations are confidential. The historic costs and values of the coal units is provided at Table 7, which is on page 26 of the Glick direct testimony. Ms. Glick also evaluated the projected performance of Evergy's coal plants looking forward. Ms. Glick used Evergy's own unit cost forecasts, market prices, and revenues. Ms. Glick again used a capacity value set at the cost of one of Evergy's contracts. Ms. Glick's analysis shows that the coal units are projected to incur costs in excess of their market energy and capacity value during the 2020s. Evergy has claimed that this calculation is confidential. The forward-looking analysis is shown in Confidential Table 11, which is on page 38 of the Glick direct testimony. In rebuttal, Evergy witness Messamore stated that the Glick analysis did not account for the cost of replacement capacity. That is false. Ms. Glick valued the cost of replacement capacity at the cost of one of the company's bilateral capacity contracts. Evergy stated in response to Sierra Club Data Request 1-12A that it also uses the value of its bilateral capacity agreements to estimate the value of capacity. Ms. Glick's historic and forward-looking projections, unrebutted by Evergy, demonstrated that customers will likely benefit from the retirement of a coal unit or coal units in the near term. Third, the company's IRP, as constructed and relied upon by Evergy, does not support Evergy's coal spending in this case. The company has neglected to evaluate the reasonableness of continuing to invest in its coal plants, despite declining economics and decreased utilization. In its IRP, Evergy studied a limited number of retirement dates nearly a decade away, 2029 and later, for its coal plants, and evaluated no near-term retirement dates. Evergy did not permit its resource planning model to select optimal retirement dates, but instead hardwired a limited number of distant retirement dates to study in its IRP. Evergy's IRP simply did not answer the question of whether the coal units should be maintained through the test year of this case. I'll now turn to the relief we're requesting. Sierra Club's requested findings of fact are provided at page 4 of the Glick direct testimony. Our proposed remedies are provided at pages 4 and 5 of the Glick direct testimony. I'll summarize them here. Sierra Club respectfully asks the Commission to make the finding that Evergy has not engaged in reasonable resource planning for its coal units by refusing to study the economics of near-term retirement. Without evaluating the cost of retiring and replacing one or more of these units, there is no reliable evidence of the value of maintaining all of these units through the test year. Sierra Club respectfully asks that the Commission make the further finding that Evergy has not met its burden of proof to demonstrate that continued investment in its coal fleet is the prudent and least cost option to provide service to its ratepayers. Sierra Club asks that the Commission disallow Evergy's test year spending for its coal units because the company has not met its burden of proof. Further, the Commission should require Evergy to conduct a full retirement study of its coal fleet using optimized capacity expansion software. This analysis should evaluate the economics of continuing to operate its coal plants relative to retirement, identify the optimal retirement date for each of its coal burning units, and design an optimal future resource mix to meet the company's projected needs. Last, given the poor to marginal economics of Jeffrey Units 1 through 3, Iatan Units 1 and 2, and Lacine Units 1 and 2, the company should signal that in future dockets, it will not be inclined to approve cost recovery by Evergy of any capital investments of more than $1 million at these plants without prior commission approval. Finally, I have one brief area of policy to address. During the last month, Congress has passed and the President has signed the Inflation Reduction Act. The act has not been accounted for in either the GLIC present value calculations or in Evergy's IRP, but the Inflation Reduction Act will fundamentally shift the economics of Evergy's coal units in two general ways that support the Commission applying close scrutiny to coal spending in this case. First, the act will reduce the cost of replacement energy and capacity by providing long-duration federal subsidies for solar, wind, batteries, and hybrid resources. Second, and by further increasing the deployment of zero fuel cost solar and wind resources and by subsidizing batteries, the utilization of Evergy's coal units in the Southwest Power Pool energy market will continue to decline, further decreasing the revenue they can earn and their value to Evergy's customers. Thank you.
Thank you, Ms. Rubenstein. Are there any commissioner questions for Sierra Club?
No questions, Judge.
Thank you, Commissioner Holzman. The bench has no questions. Thank you, ma'am. Let's move on to Office of Public Counsel.
The Office of Public Counsel does not have any opening for this issue. Thank you.
Understood. Let's get into our witnesses. The first on my list is Evergy's witness.
Evergy calls Kayla Messamore to the stand.
Thank you. If you would please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. Go ahead and have a seat. Your witness, Mr. Zopes.
Thank you, Judge. Please state your name
Kayla Messamore,
and by whom are you employed,
Evergy,
and what is your position there?
Vice President, Strategy and Long-Term Planning.
And did you prepare in this case rebuttal testimony, both a confidential version marked Exhibit 55 and a public version marked Exhibit 56, and surrebuttal testimony that has been marked Exhibit 57?
I did.
Do you have any changes or corrections to those two pieces of testimony?
I do not.
Okay. And if I were to ask you those questions, would your answers be as set forth in Exhibits 55, 56, and 57?
Yes.
Okay. And were they given under oath?
Yes.
Judge, at this time, I move the admission of Exhibit 55 confidential, Exhibit 56 public, and Exhibit 57.
Thank you, Mr. Zobers. You've heard the motion by counsel. I will not repeat the exhibit numbers as they were expressed very clearly. I will combine the question, as is my habit. Are there any objections to the admission of Exhibit 55, Exhibits 56, and Exhibit 57? Hearing none, they are so admitted. Go ahead.
Thank you, Judge, and I tender Ms. Messamore for cross-examination.
Thank you. Sierra Club is first for cross-examination.
No cross, thank you.
Thank you. And also, I'm going to call on Sierra Club again. I did not make clear a quick announcement for Ms. Messamore's testimony. The parties have agreed that there will also include cross-examination on issue Roman numeral 2, the Sibley, and issue Roman numeral 5, FAC. I apologize for not making that announcement earlier. Sierra Club, with that information, any cross-examination of Ms. Messamore?
No, Your Honor, thank you.
Thank you. And that will go to staff.
No cross, Your Honor.
Thank you, Mr. Cosper and Mr. Kleiser.
No cross, thank you, Your Honor.
Thank you. That will come to commissioner questions. Are there any commissioner questions for Ms. Messmore? All
No
right.
questions, Judge.
Thank you, Commissioner Holzman. The bench does have a couple, but we're going to go back to those other issues. And I believe these are both on Sibley.
Okay.
Would you define the, quote, expected value basis, end quote, please?
Sure. Is that from my testimony that you're reading from? Or is it a general question about the IRP and what expected value means there?
I would like both answers.
I think the answers are the same, so it should be
Excellent,
fine. I just
excellent.
wanted to make sure.
We need it for the record so that we
Okay.
have something to refer to.
So in the IRP, we have a range of scenarios that are evaluated. They all produce different revenue requirements at the end. So you're producing a net present value revenue requirement in each of the scenarios modeled. From there, each scenario has a probability assigned to it, and then you use that probability times the revenue requirement in a given scenario, and then add them all up to get to an expected value. So it's essentially a probability weighted average revenue requirement of a given scenario, or a given resource plan.
I want to walk through that because I think I can do this without embarrassing myself. You set the net present value for the utility, and then you compute several scenarios, how things might work out, 1, 2, and 3. You then figure out how much the utility, the income of the utility based on each scenario, income may not be the right word, and average those three outcomes, and that's your answer, so that when the utility is planning for its financial recompense, it is looking at any of those scenarios and getting an average instead of having to pick one and be rather committed to it. Or
Sort of. So the clarifications that I'll make are the revenue requirement is calculated in each of the scenarios. So for the 2017 IRP, as an example, there were 18 different scenarios. Each scenario had a different load forecast, a different market price forecast. So those market price forecasts drive ultimately different fuel and purchase power expenses, which in turn drives different revenue requirements in each of those 18 scenarios. And then each of the 18 scenarios also has a probability. So, for example, a high load, high gas, high carbon tax would be a lower probability than kind of a mid forecast. So you use those probabilities to calculate a total or an expected value revenue requirement. The one other clarification, that's used to assess the relative economics of different resource plans. It's not necessarily doesn't determine our financial compensation in the end. It's just used to assess the economics against each other of different resource options.
okay, thank you. I have one other question. What changed after the Sibley plant upgrade to give them and I'm going to state for the record, I'm using air quotes, give them a life until 2040? We've heard testimony about the depreciable life or the expected life. 2040 seems to be that date. What changed? We have a 50 or 60-year-old plant, and then some repair was made, I would assume, and then that was given a new life extension. Can you walk us through that?
I can't speak to the specific upgrades. That wasn't included in my testimony, but at Sibley, there were investments in environmental retrofits is a large part of it. So that's really all I could cover for that.
Okay, thank you. That will take us to recross examination. Let me check my list. And we go first to Sierra Club. Any recross examination based on the bench questions?
No, Your Honor, thank you.
Thank you, and then that will go to staff.
No, Your Honor, thank you.
Thank you, and then that will go to Office of Public Counsel.
No questions, thank you.
And then we go back to redirect from the company.
I have a couple of questions, Judge.
Go ahead.
Ms. Messamore, Judge Hatcher asked you about the 2017 Integrated Resource Plan update. Is that correct? Okay. Now,
Yes. Sorry, I nodded.
I'm going to ask the court reporter to mark as the next exhibit in order, and I'm sorry, Judge, I don't have that number handy for Evergy.
138, Exhibit 138.
I'm not sure how to deliver a copy of this to Sierra Club, but since they didn't have any questions, I'll simply describe, and let me hand out copies to counsel as well. Ms. Messamore, I've handed you what's been marked as Exhibit 138. It is a portion of the Integrated Resource Plan Annual Update for 2017, but I would like for you to describe this to the bench at this time, and then I would like to ask you some questions. So,
Your Honor, I'm going to raise an objection. I believe this is outside the scope of redirect. Your only question regarding this was to define a term, which was defined.
Judge, my response is she responded to your question by relating it to the 2017 IRP, which I believe was your question, and she talked about how Sibley was part of that analysis, and so I believe that is within the scope of the questions asked by the bench.
Your Honor, if I may respond, this raises a due process concern because they're attempting to introduce new direct evidence that I have not had an opportunity to cross on.
I'm not going to allow it, Mr. Zobrist, because I was not interested in the integrated resource plan, just the term, and then how the formula for the different scenarios.
Well, Judge, that's exactly what I was going to get into, and that's just the portions that I intend to ask the witness questions about. It's actually page 46. If I could voir dire her or ask her a preliminary question to look at that page, perhaps that would address Mr. Kleiser's concern. Without going into the numbers, but just saying, what does this page 46 depict, and how does it relate to what she was explaining to the bench?
Yeah, I reversed myself. Go ahead, please.
Okay. Ms. Messamore, would you, well, first of all, just describe this document in general without going into details, and then I'm going to ask you about page 46.
Sure. This is, at the time, Greater Missouri Operations Annual Update, which was filed in 2017 as an annual update to the 2015 Triennial IRP.
Okay, and just for the record, KCP&L, Greater Missouri Operations Company, is the predecessor company of Evergy Missouri West, correct?
Yes.
Okay. Now, just turning to page 46, would you explain to the commission what that table there represents?
Sure. So this is showing the expected value revenue requirement, which is what the bench asked about. So each plan shown here from 1 to 15 represents a distinct resource plan, which was then modeled through 18 different scenarios and to calculate a probability weighted or expected value revenue requirement, which is what's shown in this table.
Judge, with that foundation, I'd like to offer Exhibit 136, pardon me, Exhibit 138 into evidence.
I would have an objection on the fact that it's well over 20 pages and we've asked about one. if you want to offer the one page that we've asked about.
Well, Judge, I believe that the portions of this exhibit are all relevant. This is a commission, filed document. We've talked about it today. We talked about it last week. I don't see any reason why this should not be admitted to evidence. I don't think it's prejudicial. I don't think it's a due process issue.
How is it not in evidence? The point of the Sibley issue, as Sierra Club is bringing up, is they or someone has pointed out issues with coal, and she is backing that up with numbers and scenarios and furthering her testimony. So
It has been discussed in evidence, and I
Right.
believe it's evidence that is already in the record. This is simply supplemental.
Well, if it's already in the record, then it's not necessary to introduce this exhibit.
No. You missed, I did not mean a rhetorical question or to start a discussion, but a serious, how come this isn't attached to somebody's testimony? Sierra Club? Ms. Mesmore, you prepared your testimony?
Yes, I did. And I think we're conflating two issues. Sierra Club's issue was on accelerated coal retirements, which is not related to this IRP. They didn't have a Sibley argument. That was Office of Public Counsel. So I think we're blending two things. But I did include the relevant numbers from this document in my testimony. I just didn't attach it.
I don't see how I cannot admit it, Mr. Kleiser.
I'm fine with the relevant numbers coming in. I have a problem with the fact that this is a very large document, and I don't want the company citing to things that weren't discussed today on other pages that I haven't had a chance to cross anybody on. If the numbers are already in the record, then they're in. We don't need this document.
Well,
Mr. Zobrist, you're an officer of the court. Is your intention to only cite the relevant numbers and page being discussed in the last 15 minutes, give or take? Is that your intent?
well, the table set forth it's table 26 on page 46, is the product of a couple of other previous tables, and I think the witness could talk about what those are. It essentially is that data there. I mean, we've been discussing this IRP for, parts of the last 2 weeks. So this is not an element of surprise. This is a document that has been filed at this commission for over 5 years. And I'm not going to ask her any more questions today beyond page 46, but to start chopping up the IRP even further, I don't think makes any sense, Judge.
And the commission also has a strong preference for whole documents and not single pages, even when only a single page is being used.
That's fine. For the purposes of preserving this issue on appeal, I need to register that I believe that there's a due process violation in as far as I have not been allowed to cross this witness regarding elements of this document which were not previously discussed in testimony or which were not discussed here on the stands.
Would my,
Judge, may I ask a question?
yes,
If the preference is for whole documents, may I clarify, is this the whole document, though, or is it just a selection of the IRP? Because my understanding is IRPs are also very lengthy, so I don't know if that...
This just relates to the Section 6, the Integrated Resource Plan and Risk Analysis Update. So I did not intend to offer all 250 pages or whatever it is.
I think the commission would distinguish a page from a whole document still as being the shorter version. However, I'm getting a little closer to understanding Mr. Kleiser's argument. Mr. Kleiser, would it be a cure to allow everyone to go through recross examination
Would it be okay for me to ask for a very brief recess before doing that? The simple problem is, I believe that there is a concern that we have raised in our briefing regarding the elements that went into their company's resource plan, and I need to go discuss that with somebody just to make absolutely sure. I may not in fact have any cross, I just need a chance to verify that.
Judge, I think that's entirely fair. I do not object to that.
The commissioner, the bench has one question. Ms. Mesmore, what are your travel plans for today?
I'm here.
I propose that we wait until 1 o'clock. We just find out if anybody has any questions. I will then ask for the admission of the exhibit, and we will then see where we are at. Let's move on with what we can get through on rate base and resource planning otherwise this morning, and we'll carve out this one little tidbit, is a term of art, for later consideration.
Okay, so to come back at 1 o'clock?
We had to come
Okay.
back at 1 o'clock anyway. That was our street lighting witnesses' first availability.
Okay. I would like to have Ms. Mesmore explain what page 46 is, because I don't believe there's an objection to page 46.
Yes, go ahead.
Okay.
I thought she already had.
I think I already explained
You
it.
did? All right. I kind of lost track here in the flurry, so. Okay. And let me ask you just one general question about IRPs. Are they typically an input to a rate case like this proceeding?
No.
Why not?
Because an IRP is a decision-making tool. It's a process for long-term resource planning. So we do it every year and triennially in full, but it doesn't provide any direct input into the rate case other than supporting decisions that the company makes on its resources.
And are the resources that are depicted in an IRP that exist, are these resources that are in the rate base of the company?
Yes.
Okay. Nothing further, Judge.
Thank you, Mr. Zobrist. Ms. Mesmore, you are temporarily excused, and we would ask that you come back at 1 o'clock. You may step down from the witness stand. That was all the company witnesses I had, and that should take us to Sierra Club's witness, which I believe is on WebEx.
Yes, she is, Debbie Glick.
Thank
Good
you.
morning.
If you would please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Ms. Glick. Your witness, go ahead.
Please state your name for the record.
Debbie Glick,
And where are you currently employed?
Synapse Energy Economics,
And what is your current job title there?
Senior Principal.
Ms. Glick, did you prepare and cause to be prepared in this case the public and confidential versions of your direct and surrebuttal testimony, which have been marked as exhibits 450, 451, 453, and 454?
Yes, I did.
And is the resume, which is attached as Exhibit 1 to your direct testimony and also marked as Exhibit 452, a true and correct copy of your resume?
Yes, it is.
Do you have any changes or corrections to your pre-filed direct or surrebuttal testimony at this time?
No, I do not.
And if I asked you the questions in your direct and surrebuttal testimony today, would your answers be the same?
Yes, they would.
And is the information in those answers true and correct to the best of your knowledge?
Yes, it is.
Your Honor, I move for the admission of exhibits 450 through 454 in this case.
Thank you. You've heard the motion by Ms. Rubenstein. Are there any objections to the admission of those 5 exhibits of Ms. Glick? Hearing no objections, they are so admitted. Go ahead.
Thank you. I have nothing further.
Thank you. That will take us to cross-examination. And the order that I have is staff first.
No cross, Your Honor.
Thank you. Office of the Public Counsel
No cross, thank you.
and the company?
No questions, Judge.
Thank you. That will take us to commissioner questions. Are there any commissioner questions for Ms. Glick? Hearing none. The bench also has no questions. So thank you, Ms. Glick, very much for your prepared testimony. Sometimes this happens. We just don't have any further questions. Thank you. You are excused.
Thank you.
Okay, that completes the witness list. Staff, I believe, said you had a witness available, and I was a little unsure of what available meant.
Staff does have Jordan Hull, who did file testimony, but my understanding is that parties did not have cross, so unless the commission or bench has anything.
No, let's get Mr. Hull's testimony. We want to admit his testimony, yes? Okay. I am ready for the numbers, Mr. Cosper.
So Exhibit 215, public, is direct testimony, and then rebuttal testimony, Exhibit 241, public.
No, sir, rebuttal?
No, Your Honor.
Okay. You've heard the motion by Mr. Cosper. Are there any objections to the admission of Exhibits 215 or 241? Hearing none, it is so admitted. I believe we are done for this. We are not. We have a couple of announcements.
Judge, I was just going to say, could we have a recess for just 5 minutes and I can confer with my client about the exhibit that I offered? And that Mr. Kleiser wanted to have more time.
I would rather not. If I may, my plan is,
Well, I was just going to say, I may be able to resolve the issue.
I think you can resolve it under my plan.
I can resolve it a lot quicker, I think, Judge,
Okay.
respectfully.
We will take a break for 5
Great.
minutes and come right back.
Thank you, sir.
Let's go off the, yes, let's go off the record. Okay, let's go back on the record. We took just a few minutes for some quick client conferences. My understanding is we have reached the end of this morning's events. We will be taking a break until 1 p.m. That is the first availability of a witness necessary for our street lighting issue. Street lighting issue will be the final issue discussed today. A couple of announcements I missed earlier this morning. Mr. Opitz and MECG have requested and been granted to be excused from the proceedings today. Also, Exhibits 135 and 136 have already been admitted. They are copies of 2 appellate cases, and those have been physically provided by Evergy this morning. Again, those exhibits were already admitted on Thursday. Last announcement is we have all the parties agreed to have a what the commission calls an on-the-record presentation, and that will occur Friday upon adjournment of the evidentiary hearing or 1 p.m., whichever is earlier. And just for our listening audience, the purpose of an on-the-record presentation is for the parties to present the high points of the agreements that they have reached in resolving this case. Any other announcements? We are recessed until 1 p.m. Thank you all. Off the record.